decision-making hearing that we do have queued up. First, for the 9 a.m. decision-making agenda, we have House Bill 2501, HB2 SD1 relating to water rights. This requires that where an application has been made for a lease to continue a previously authorized disposition of water rights, a holdover may be authorized annually until the pending application for the disposition of water rights is highly resolved, or for 3 years, whichever is sooner. Requires that the holdover is consistent with the public trust doctrine and any applicable law. Makes an appropriation, repeals on June 30th, 2019. Members, I know that you have received a good number of testimony on this particular measure, probably flooding your email boxes quite a bit. So what we're going to be doing, we have been mulling over this particular measure to take a look at how we can address this long-standing issue within DLNR as well. We appreciate the work subject matter has done to this particular measure as well, and have got his concurrence in terms of some of the amendments we would like to make as this bill continues to move forward. Back over to the House for their consideration, and very likely also into conference. What we'd like to do in making amendments to the measure and passing it forward is, first of all, what we'll be doing is inserting an appropriation amount into the bill so that it's clear how much DLNR feels it would take to actually effectuate the terms of the measure, which is an appropriation of $150,000 and 2 full-time positions. This would be for 1 project development specialist for the land division and 1 hydrologist for position for seaworm. So we're going to be adding those specifics into the measure. Then this would be to assist with processing holdover permit applications, something that's been a long-standing issue, something that's very important to do. What we're also going to be doing is adding an annual reporting requirements to the legislature that goes beyond the date of the sunset. That will be required prior to the beginning of each regular session until the regular session following the sunset. This annual report will include the status of dealing with the holdover permits, actions taken during the interim, and any suggestions for legislative action appropriation that they might have. But we're also going to be looking at, while we do note very clearly that we have received from both the testimony that we got from individuals, as well as from the opinion that this affects a number of different potential individuals. There are approximately 10 other water local permit holders on Maui, Kauai, and Hawaii Island that were impacted by the court case. What we would like to do is amend this measure so that it specifically addresses these individuals. So what we'll be doing is amending section 4 of the measure and removing the words pending before the Board of Land and Natural Resources as of the effective date of this act. Or, so essentially this is going to be prospective from the date of the effective date, so as to provide protections for these particular individuals, for the cattle ranchers, for the farmers, and other individuals that potentially would be impacted as a result of the ruling. So we're going to make it prospective from the effective date and really take care of a lot of those other individuals that were pulled into this as a result of the ruling. So that's going to be the recommended amendments that we make. I'm sure that now the bill is very different, so likely there'll be conference discussions moving forward, but now there's a little bit more clarity in terms of wanting to provide some water protections, as well as some enabling provisions and appropriations for DLNR in terms of giving them some resources as well as some bodies to be able to deal with this issue. And there's still, again, that 3-year sunset in there, which is not 25. So any questions or comments, members? Oh, Senator here, and then Senator English.
Thank you, Chair. The amendments, adding the staff to DLNR is very well received. The annual reports is a good movement because it does address the underlying problem, which is the delays in moving the permits. Obviously, these water permits that created this crisis, if it is a crisis, go back many decades. And the court ruled, I'd like to remind everybody that the court ruled in January that these 4 water permits for 1 company can no longer continue to be rolled over and rolled over and rolled over. So the court is not ruling on every permit in the state of Hawaii, but 4 permits. Over the past month or 2, there has been threats and fears and fear mongering, in my opinion, where it has been shouted out that everybody's gonna lose their permits. 900 or 300 permits are out there. There's 9 other water permits, and they're all in jeopardy. And I would remind everyone again that the court ruled on one specific set of permits. So this bill now opens it up to the 9 other water permit holders. But I would argue that this is destroying the permitting process, because it doesn't, it just buys time. As unfortunately, as Deal and R testified in their hearing on the subject matter, this buys the status quo. And it's the status quo that is exactly the problem. The court ruled in January that in the absence of in-stream flow standards, the Board of Land and Natural Resources has the authority and the wherewithal to make interim decisions. The court did not say that the sky will fall and the world will end. When County of Maui said, but we have people in residences that are in need of water through the system, the court stated any action on that. In the subject matter hearing in the first go-round of the Senate version, Waterland and Ag Chair suggested that, basically told Alexander and Baldwin that they probably should get going on their environmental impact statement, which they have not done. Remember, this is 15 years in the making. Native Hawaiian Legal Corp had challenged who were to pay for the EIS, but they dropped that verbally a few years ago and formally at least a year ago. So this impending crisis is not real. This has been trumped up. I would point out that diversified agriculture, which we hear so much about, and all of this great diversified agriculture, which we all hope comes to Maui, uses half of the water of sugarcane. We all know that sugarcane is a very thirsty crop. It uses approximately 4,800 gallons per acre per day. It uses a lot of water. Diversified agriculture uses about 2,500 gallons. So even if we were to keep 3,600 acres in active agriculture using the whole thing, we still only need approximately half of the water that has been historically used. We have people in streams in Maui. Our hearings were very long because people were flying over from Maui, hollow farmers, taro farmers who historically have lived off the land. They don't have in-stream to provide for the fish and the taro that they have lived on for generations. And so now what they're saying is, here we are, we're at the moment when this should be resolved. But this bill is not going to do that. This bill is going to continue the status quo. It's going to buy some time. For what? To continue using the water that they've ever used. There's a sunset. Well, I would remind anyone that observes the legislature, sunsets rarely come. You know, how often do we extend sunsets or repeal sunsets? So I'm not confident that a 3-year term is going to magically come, because I don't believe, by all accounts, that there is any interest with this bill to resolve the underlying issues. Navai'eha, the 4 streams in central Maui, was resolved. Once the landowner stopped fighting the courts and stopped going, they did come to a resolution on the water usage and their water rights. The Native Hawaiians who have come and so passionately filled up our emails, they have said, we just want to share, give us some stream flow. So there's no reason that one large holdover plantation company from generations ago, there's no reason why they need to continue to have all of the water they've ever needed without any long-term permit. I would remind everybody that the water does not belong to one company. The water is a public trust. It is a public trust. This is the state of Hawaii. Water is life. The highest priority, according to our Constitution, is the minimum in-stream flow standard to keep the streams alive and our nearshore waters. Without our fresh water going into the sea, we don't have fish. If we don't have the second priority is the Native Hawaiians and their customary rights and ability to grow taro. Third is diversion. That's the way it is, folks, like it or not, that's the way it is in the state of Hawaii. So, why haven't we gone to the EIS? Why haven't they applied for the stay? Why has Alexander and Baldwin not applied for a stay? They don't need to. We're gonna give them a buy to continue the status quo. If they apply for a stay, they're going to have to identify how much water they need for this nebulous diversified agriculture plan that is coming at some future date. The EIS could begin. They could have options of ranges of water that they intend or need to use, but they've not begun that process. They've not applied for the state because, again, they have to identify what is the amount of water they need and when will they complete the process. The court's not going to give them a blank check, so they've come to us. And here we are on the verge of giving them that continued status quo. As we've all admitted, or as was mentioned already, this is not a pending threat to the other 300 ranch and land leases. And even the water leases, they're not actively being challenged. They didn't lose in court. So this bill now with the proposed amendments is no longer going to apply to one landowner, but to 10, okay, or 13 various permits. It's not solving the problem. Parts of this bill are good. They're doing it. This is just a travesty. This is the bill that I feel so passionately about, and I really appreciate you folks for listening to my plea that there is a process to move forward. The court will not, come on, the court will not say, boom, open it all up, you can't have any water. The court has instructed DLNR and Alexander and Baldwin to get busy on their long-term leases. This bill is going to delay that, it's going to create greater problems, and I'll finish with one more thought. Super Ferry 2 was thrown out by the court because it was special legislation to address a specific entity. This, one might argue, is special legislation that is not going to solve the problem. We're going to create other legal challenges. So let's get busy trying to fix the underlying problem. Let's get busy bolstering DLNR. Let's require Alexander and Baldwin to come to the plate and the Native Hawaiians. Let's go, let's get those in-stream flow standards. But saying no, never mind, keep using all the water until some future date is unacceptable. So please, and fair, Thank you.
Thank you. I appreciate the efforts you made to amend the bill and to be clear that, the court ruling is broad and it applies to a number of other permit holders. So I appreciate you trying to address that. To be clear, if you listen to what the chair put on the table, actually, to put it in layman's terms, all the other permit holders are protected, and the only one that has no protection in this is A&B. So that's what the chair put on the table. My understanding of it, right? So, but let me just say what I need to say. I come from Hala, and when you talk about those Native Hawaiians, that's me. Those are my direct family, and people that I live with, and people that I grew up with, and I will return to, and I'll be buried there when I die. But the point is this, I have a very large district. It's like threading a golden needle. Because on the one hand, I have 37,000 residents in upcountry that need water. On the other hand, I have my family in Hala that needs flow streams, inflow streams. What is the correct term? The streams to flow. So it's a very difficult one for me. I think that we can find a middle path, and I think that we're much closer to it than what the chair proposed here. But when it all is said and done, for me the most important thing is family, and being able to go home, and being able to live in my area. So I'll vote no on this particular measure because that's what one part of my district wants, knowing full well that it affects 37,000 other residents in my district. It's my hope that at the end of the day we can find something that can satisfy the Native Hawaiians, my people, can satisfy people that need water and at some point even satisfy keeping Central Maui green. Because, you know, if you go back and look at the Hawaiian newspaper accounts of before the plantation, they talk about the great, this is in Hawaiian language, they talk about the great dust storms that would go through Central Maui. And in fact, the whaling ships, you know, they talk about how the whaling ships would find Maui by looking in the sky for the red dust and the clouds of dust that went across Central Maui. So when the plantations came in, yes, they took water, and by the way, that was the descent of King Kalakaua, created a engineering feat on this planet by using gravity flow to move water from one side of the island to the other. But this is generational, and it is ingrained in my family's east side knowledge that, you know, an injustice, a great wrong has been inflicted upon our families for many years. I'm hoping that, you know, in the end we can find a way to right that. We can find a way to bring some settlement and release and lihi and ho'oponopono and those other important aspects, so that maybe our children will not have to live with this burden. So with all of that in mind, you know, I put this before you that I have to vote no on this particular measure, regardless of the great strides that the chair made moving this forward, because I think it does help the other permit holders. But nonetheless, I vote no because it's a reflection of my ancestry, my family, and the people of East Maui. Thank you.
Any other comments or questions, members? Okay, Senator Harlan-Little?
Thank you, Chair. I wanted to thank the prior two speakers for sharing their thoughts. Normally, I have an easy time deciding to vote yes or no. This is a bill where I'm having great difficulty. This one and the next one. And on this one, I kind of flip-flop. I was in fact no to begin with. And I appreciate all the passionate discussion to the people on both sides of the issue. And, you know, I switched to a yes, and after listening to today, I'm back on the fence. So I just wanted to say that, I guess at this point, I will support the chair's recommendation, knowing that this will go to conference, and hopefully that some of the issues can continue to be worked on, and we can find some agreeable solution as this moves forward. But, this is a difficult one. Thank you.
Other questions or comments? Okay, if not, Senator Townsend, you have comments? Senator Townsend?
I'll be very brief, only supporting the chair's recommendation. And with the common knowledge, and certainly we've heard the gentleman from Hana, the gentleman from the North Shore, and their passions and their differences in not supporting this particular measure. But we did not get to this overnight. It took years to get here. It'll take us years to get out of it. And I would hold ANB's feet to the fire to having us give them a little bit more time to work it out means that they can't come back to us in 3 years and say we haven't worked it out. We expect answers, we expect action, and that's why I'll be voting in favor of this particular bill. Thank you, Chair.
Any other questions or comments? Senator Jonathan?
I share the concerns of both Senator Revere and Senator English. I do have a lot of faith in all of the stakeholders that something will be resolved. And I hope that there is something that comes out that will be a win-win for everyone, that is right for our people. I think there's a lot of opportunity to help facilitate this discussion. We'll see at the end what the final product is, if it passes. Thank you.
Senator Moore?
Thank you. I'll be supporting this measure, and what I like about it is that the chair has included and literally considering that the in-stream flow study is going to be in effect once the appropriation is added to the bill as well. Let's remind ourselves that sugar is no longer going to be here. We had an incident in North Kohala when the sugar plantation closed nearly 40 years ago. Until today, I'm still trying to find water for my farmers in North Kohala. We've had appropriation last year. We're still studying how we're going to help them. And in this particular issue, there is water. And what I like about it is, albeit DLNR's, I guess, the neglect in addressing this situation a long time ago, but it seems like we will be dealing with in the 3 years hence. Keeping in mind that agriculture needs water. And part of this measure as well includes many in my district and on my island. Water is so important for this state. Agriculture, we talk about it every day. Every year I come here, we're talking about water, how we're going to support our ag industry. And if we can't take care of this particular issue before us, there is a sunset in 3 years. Let's get with it, folks. Are we going to delay this and not address this issue? DLNR is there requesting help from us in any of its appropriations that they put in the measure, and the administration, I'm sure, will follow through. I like what the chair has done in moving this out and clearly addressing this issue with judiciary as well, the recommendations forth before us. So I am going to support the chair's recommendation to continue to move this forward. Thank you.
Any comments or questions? Just so we can be clear before we go ahead and take the vote too, just wanted to know what we are specifically voting on. We're going to be including the general funds appropriation one of $150,000 in 2 positions. That's 1 project development specialist for the land division, 1 hydrologist for seaworm, and this is to assist with the processing of holdover permit applications. What we're going to do is also include the annual reporting requirements to the legislature, and this will need to submit to us prior to the regular session until the regular session following the sunset. Reports to include the status of dealing with holdover permits, actions taken during the interim, and any suggestions for legislative action or appropriation. We're also going to note in the committee report, I think that's what Senator Inoue was alluding to, that DLNR did request $1.5 million to fund an in-stream flow standard study. I think that's phase 2. That's something the Senate would like to take up in the budget. As you know, with the budget tomorrow, a couple of hearings we've got coming up in the next couple of days. That's a very big issue, so we would like to take that in the budgets. We're not going to be inserting that one into this vehicle as well. That is something that we also view as very important. So thank you to DLNR for putting that forward. And then finally, what we will be doing is in section 4 of the measure, we will be making it clear that this shall apply to applications for the disposition of water rights that are filed with the Board of Land and Natural Resources on or after the effective date of this act. So this will not apply to those currently pending before the DLNR as of the effective date of this act. So it's prospective for the act. So with that, members, thank you very much for your patience and for all of the many heartfelt comments, very thoughtful comments. And with that, I'm going to chair for the vote.
Your recommendation passes on to Chair Sotomayor.
Aye.
Vice Chair votes aye. Senator Chano, please. Senator English.
No.
Senator Calatario. Aye. Senator Harimoto.
Aye.
Senator Inoue.
Aye.
Senator Revere.
No.
Senator Taniguchi.
Aye.
Senator Lakai.
Reservations.
Senator Sloan.
Reservations.
Recommendation adopted.
Thank you very much, members.